Welcome to Case Law Minutes by LitigationHelp.com, your public legal education provider. My name is Huizinga, and in this video we are going over the case of LL and MC 2013 ONSC 1801, which is a Superior Court of Justice case from 2013. This video will deal with Section 9 of the Child Support Guidelines and how the 40% threshold is calculated. But first, we need the disclaimer. This presentation is for general legal information only. For advice specific to your case, please consult a lawyer. Section 9 of the Federal Child Support Guidelines provides a 40% threshold before shared parenting is reached. This is important because if a parent hasn't reached the 40% threshold, they are responsible for the full table amount of child support as directed by the guidelines. Once a child is spending more than 40% with both parents, then Section 9 of the guideline kicks in and the amount of child support may be reduced. This is despite the fact that access parents must clothe, feed, and house children overnights. They are not afforded any money from the guidelines until the 40% threshold is met. This case discusses the different ways in which this 40% threshold is met. According to Section 9 of the Federal Child Support Guidelines, the threshold for shared custody is reached when each parent has a minimum of 40% access or custody time with the child. Section 9 states the following: where a spouse exercises a right of access to or has physical custody of a child for not less than 40% of the time over the course of the year, the amount of the child support order must be determined by taking into account A, the amounts set out in the applicable tables for each of the spouses, B, the increased cost of shared custody arrangements, and C, the conditions, means, needs, and other circumstances of each spouse and of any child for whom support is sought. In paragraph 24, the courts found that although the method of calculation is not set out in the legislation, it is clear that 40% is the minimum period of access time fixed by Parliament as sufficient to trigger a child support calculation under Section 9 of the guidelines. Courts cannot ignore this mandatory requirement in favor of rounding up in the case of access time that is close to 40%. I recognize this calculation brings the matter close to 40% and appears arbitrary. However, in my view, it is not open to the court, faced with the express wording of Section 9, a court order particularizing the right of access and the measure of time that falls under the requisite 40%, to ignore the words mandatory requirement chosen by Parliament. In other words, in the words of the Alberta Court in LC and ROC 2007 ABCA 158, there is no place for deeming parenting time to be what it is not. How is the 40% calculated? The court found under paragraph 34, as demonstrated, the courts do not have discretion to round up or down to reach or avoid a finding that a parent has access 40% of the time. 40% is fixed as a firm threshold. This is acknowledged that when parents are exercising that level of access, child support determinations need to be approached in a different manner, given the reality of the costs incurred by parents in these types of access and custody arrangements. It is therefore desirable to be as precise as possible when determining the reality of parents' access and custody situation. There is no place for deeming parenting time to be what it is not. Arguably, it is equally unfavorable to deem non-parenting time. If we are rounding up or down to larger portions of a day rather than using the most precise information available, deeming parenting time is inevitable. While it is important for the courts to not get lost in the numbers entirely, there will necessarily be an accounting of time and a question of whether the party exercising access does so in a manner that exceeds or falls short of the 40% threshold. The two most common approaches to calculating access and custody time are in days and in hours. If using days, to reach 40%, the access parent must have the child in his or her care for 146 days per year. When calculating in hours, the 40% threshold lies at 3,504 hours per year. In his paper, A Practitioner's Guide to the Economic Implications of Custody and Access under the Divorce Act and the Federal Support Guidelines, the author points out that no matter how the calculation is completed, the relevant period of time the child is in care and control of the parent is not the amount of time that the parent is physically present with the children. The calculation includes the time the child spends in swimming lessons, at daycare, at school, or with a nanny, so long as the parent claiming this time is the parent who, during that period, is responsible for the well-being. In paragraph 39, in line with this approach, the custodial parent will be credited with time that a child spends sleeping or at school, except for those hours when the non-custodial parent is actually exercising rights of access or the child is sleeping in the non-custodial parent's home. If there is a fixed drop-off time for access parent to deliver the child to school or daycare, and the child returns to the custodial parent at the end of the day, the time during school or daycare is typically credited to the custodial parent. The court then applied this approach to the case at hand. Where to get this case? You can get this case from CanLII.org using the link in the description below the video or the link displayed in the video. Thank you for taking the time to watch this video and tune in to other videos from the most cited list of family law cases.